Our agenda for today. So we're going to be having a look at what new legislation is on the way, obviously, and there is quite a bit. There's quite a lot for us to get through because whilst for the last couple of years or so, actually, it's been very quiet on the legislation front, the employment legislation front. We didn't really see anything from an employment perspective happening under the premierships of either Boris Johnson or, unsurprisingly, Liz Truss. I guess she didn't have that much of an opportunity to do so. But we've now got quite a flow of legislation that's going to be coming through in 2024 and 2025. I have to admit, we're not very clear on a lot of the dates yet. So in terms of implementation dates, it's not quite clear as to when in 2024 or whether it's going to be 2025. But I'll try to give some indications as we go through. But just to warn you that we haven't got certainty on those points. Also, we're obviously going to be having a look at what new and important cases have come through in the tribunals, in the employment tribunals and the employment appeal tribunals. So we'll be having a look at some of those as well. There's also been lots of new pieces of guidance that have been published, some really helpful pieces of guidance, cover many different topics, such as menopause and transgender issues. So I'll be pointing you in the direction of those. And again, when you get the slide deck come through, when I send that through to you, I'll make sure that all the links are in there so that you can just easily navigate your way to those pieces of guidance that have been published. And like I said, some of them are really quite helpful, and also some of them are just very important that you need to be aware that that they exist, what they contain. The legislation. First of all, we have got the Neonatal Care, Leave and Pay Act of 2023. As you can see, I'm flagging up straight away, but this one is expecting to take effect in April 2025. So quite a bit of time yet. Now, the reason that there's quite a bit of time yet is because although the Act has been published, there's lots of regulations that are going to have to follow to implement this. But just to sort of introduce the legislation itself. So the intention of this new family leave provision is to provide some certainty to business and of course to society about how to deal with neonatal care in a structured way that doesn't happen at the moment, because there is no provision for neonatal care within employment legislation. So currently everyone is just simply relying upon the goodwill and charity of a business, albeit that I appreciate that there are some other ways in which you perhaps can take leave, but I'll address that as we go through. Of course, many businesses are extremely generous and compassionate in these sorts of circumstances, but some are not. But even those that are generous, they don't have the structure within which to work. And so this legislation is going to provide that structure, and it's going to provide that certainty so that employees know how to interact with one another if and when a child is unwell after the birth. So if we have a bit more of a detailed look at what the provisions are. So it's going to provide an entitlement to 12 weeks additional leave. So like other family-related leave and pay rights, it will be paid at the statutory rate that is currently £172.48 per week, or 90% of the average weekly earnings, whichever is the lower. So let's have a look at how this is going to work. So first of all, it's going to be a day one right to leave. So that means that the entitlement to the 12 weeks of neonatal leave will be triggered upon your first day of employment. So if you join your employer and then, for example, within a week you have a baby, or your partner has a baby and goes into neonatal care leave, then you will have the right to this 12 weeks of leave. But, and there is a little bit of a but here, is that then when we look at the pay, so this pay of £172.48, or the 90% of average weekly earnings, that is only triggered if you have 26 weeks of continuous service. So it's mirroring the qualification periods for maternity leave and maternity pay. To be eligible, the individual must be an employee and have a parental or other personal relationship with a child who is receiving or has received neonatal care. Now, before you then ask, well, what on earth do you mean by personal relationship? Well, that we don't know, because that's part of the detail that we're going to have to wait to see as this Act is implemented. And so when this Act is implemented, we are going to see 7 sets of regulations. Yes, 7 sets of regulations that are going to put this into place. And so obviously that's going to take some time. But when we look at this qualification of, what do we mean by a personal relationship, we're expecting it to not exactly mirror, but in some way be very similar to the provisions in parental bereavement leave. So it's going to include natural, obviously natural parents, adopted parents, perhaps a parent under a surrogate arrangement, what's called a parent in fact, which is defined as someone who has or would be expected to have day-to-day responsibility for the care of the child. And then we get into, well, what do we mean by neonatal care? Again, we're going to have to wait to see how the regulations actually define it. At the moment, what the government is saying, or what the Act is saying, I should say, is that neonatal care is care of a medical or palliative kind. It's got to start within 28 days of the child's birth, and it must continue uninterrupted for at least 7 days, although we have been told that the regulations may permit an interruption to that 7-day period in some circumstances. And we also expect the regulation to set out some specific rules about what will happen to the leave and pay in circumstances where neonatal care is required on 2 or more separate occasions. So as you can see, there's still quite a few unanswered questions yet, or should I say at this point. But we will wait and see what transpires in the regulations themselves. Now, the duration of neonatal leave must be at least 1 week and a maximum of 12 weeks. It has to be taken within 68 weeks of the birth. Now, for those of you who are quick at maths, you will realise that 52 weeks maternity leave plus 12 weeks neonatal care leave takes us to 64 weeks and not 68 weeks. I can only assume that there's some wriggle room being put in this timeline just in case, or should I say, to permit an individual to also take 4 weeks of parental leave, which you're entitled to take during each year up to a maximum of 4 weeks in each year of that child's birth. So what this means is that employees will be able to take neonatal care leave either at the time that the baby is receiving the neonatal care or indeed after that period. So this is to enable employees to be able to use other forms of family leave, such as maternity leave, paternity leave, and shared parental leave. So this is partly why it also gets rather confusing. I think it's fair to use the word confusing, because, or perhaps complicated is the better way of putting it, actually, because what we've got is that we've got lots of different forms of leave, and we've got lots of different ways in which they can interact with one another. And so what these regulations have therefore got to provide is they've got to provide for the fact that there are lots of ways that this could work out, and so those options need to be set out in the regulations in some detail. Obviously, that means that, given that, obviously, for those of you who are au fait with the shared parental leave regime, that can be quite complicated. And then whenever companies are producing policies in relation to shared parental leave, they end up being quite long because there's lots to explain. And I suspect that might be the case with neonatal care leave as well. So short informal notice is going to be acceptable. It's going to be acceptable when you take the leave at the time that the baby is admitted into hospital. Where you are taking the leave at a later point, there is going to be a more formal requirement for notice. It's indicating it's going to be at least 1 week, where where that leave is taken at a later point. So if you are, for example, if you are on maternity leave at at the point that the baby is taken into neonatal care, you don't have to take the neonatal leave at that point. Obviously, as we said, you can take it within 68 weeks of the child's birth, so you might be tagging it onto the end of your maternity leave, for example. But of course, what that means then from a payment point of view is that then perhaps we're going to be paying 39 weeks of maternity pay. Then we're going to have a 12-week period of no pay. And then if the neonatal leave is then paid at the end of that, then we're then going to be triggering payment again from weeks 52 up to 64. So there's lots of complicated ways in which this is perhaps going to work. We're also expecting the regulations to set out that the right to return to work will be to the same job, unless that's not reasonably practicable to do so. So in the same way that in the period of additional maternity leave, so the 26 to 52 week period of additional maternity leave, where you don't have to return the woman who's returning to work from maternity leave into exactly the same job, there is some wriggle room that employers get. Although I have to say that I come across this issue very rarely indeed, because most employers don't exercise this rather limited right that they have got. And one other point, one other thing that has been mentioned, but again, we'll need to wait and see when the regulations, what the regulations will say when they're published, is whether there will be a protection against redundancy. Currently, if a woman is on maternity leave and is at risk of being made redundant, she must be offered any suitable alternative role that exists over and above any other employee. We anticipate that this protection may be replicated in the neonatal care leave. So we'd also assume that it would apply equally to men as to women, perhaps, but we'll have to wait and see on both of these points. In any event, I've got a point, some other legislation to talk about later about this protection in relation to women on maternity leave and what happens in redundancy and the extension of that protection. But I'll cover that in a few minutes. One point we are clear on, though, is that employers will have to make their usual pension contributions as though the employee was receiving full pay, whereas any minimum employee contributions will be reduced to account for their reduced pay during that period of leave. So essentially, the employer carries on doing exactly the same, and the employee can reduce their contributions. So that's neonatal leave and pay. The Carers Leave Act of 2023. Now, immediately, you can see a bit of a change in the structure of this legislation just from the title itself. So this is the Carers Leave Act of 2023. It's not the Carers Leave and Pay Act of 2023. So the Neonatal Care Leave and Pay Act obviously provides for payments as well as leave. The Carers Leave Act only provides for leave. So the entitlement of leave is to 1 week's unpaid leave per year. We understand, and as before, we will need to wait for regulations to be published to confirm the approach that the government intends to take. But we expect this to be a day one right again. So individual employees will be able to take their 1 week's unpaid leave per year from day one of employment. When we begin to look at who this may cover, it provides leave in circumstances where the employee is providing care to their spouse, their partner, their civil partner, child, parent, someone who lives in the same household as them, or somebody that reasonably relies on them for care. In addition, the individual will also be required to have a long-term care need. Now, this would be defined as either a long-term physical or mental illness or injury that requires or is likely to require care for more than 3 months, a disability as defined under the Equal the Equality Act of 2010, or issues relating to old age, with some additional exemptions, for example, covering cases of terminal illness. So we can see from this that the breadth of this coverage is really quite wide. And given again that the intended approach to this is going to be done in a very light touch way, and what I mean by that is that the process around the leave is intended to operate it flexibly in a light touch way, which means that it will be a self-certification regime. So in terms of employers that may be seeking evidence in relation to the qualification of the person that they're caring for having a disability under the Equality Act or having issues in relation to old age, then it would appear at this stage that there will be no right for you to ask for that evidence. But in the same way that we see with other light touch regimes, so say, for example, with shared parental leave, the purpose of shared parental leave is to be taking care of the child that you are taking the leave for. It's not for, say, for example, for you to be using the time for something else, for going away and leaving your family and leaving, for example, if we're talking about, the partner of the mother here, it's not for the partner of the mother to take shared parental leave and then disappear off on a 2-month holiday on their own or something like that. That's not the purpose of the leave, and therefore in the self-certification process in relation to taking that leave, you have to declare that you're intending to take it for the care of the child. And if you don't do so, then that's potentially a disciplinary offence. Obviously, then you need the evidence that sits around that. But it doesn't look like the regime is going to provide any right for employers to ask for certification of the illness of the person that they're going to be caring for. Clearly, there are going to be some template forms for employees to complete and signify and confirm the reason for the leave. The notice that is required is going to be relatively short. But somewhat differently to, say, for example, time off for dependents, it's not for emergencies, but rather for planned events such as appointments. The notice requirement for this reason is similar to the quite little used notice requirements that are set out in the working time regulations for holidays, which is double the amount of leave that is requested. But in this instance, there's also an additional day added. So if I just give you an example, therefore, if an employee wants to take half a day's carer's leave, then they would need to give 2 days notice of that leave, because it's double the amount of the leave that they're requesting. Half times 2 is 1 day, and then plus another day gives 2 days notice. If the leave period that they want is for 2 days, then the notice requirement is 2 times 2, which is obviously 4, plus 1 day, which then gives us 5. So 5 days notice for 2 days of carer's leave. An employer cannot deny the leave, but it can be postponed. And it can be postponed when they consider that the operation of the business is going to be unduly disrupted. What isn't quite clear is how long the leave can be postponed for. But what about time off dependence? So how does this work with the whole time off dependence regime? Isn't this simply a repeat of that entitlement? Well, clearly there is an overlap, as there is also an overlap with several other rights to leave which a carer might rely upon. So we've got time off dependence leave, we've got unpaid parental leave. Obviously, that's if the caring is to do with a child rather than with perhaps an elderly parent. We've got annual leave, and we've also got the possibility for a request for flexible working under the Employment Rights Act, albeit that, of course, that's more of a permanent arrangement and isn't just about taking the person you care for to an appointment or something similar to that. But the purpose of carers leave differs from when an employee might take time off for dependence or unpaid parental leave. Time off for dependence leave is generally available for emergency caring situations. It has no notice requirement. And also it's limited to a reasonable amount of time off. policy intention is that carers leave is, in contrast to the time off dependence, it's going to have a minimum notice requirement, and as such is to be used by eligible employees for planned and foreseen caring arrangements. And in contrast to unpaid parental leave, which is of course limited to parents of children under 18, carers leave is going to be available to a much wider range of caring situations, excluding general childcare, except where the child meets the definition of a dependent with a long-term need. So carers leave is intending to fill a bit of a gap and give employees other options. The third piece of legislation, now this hasn't got quite as far as these other two pieces of legislation. So the Neonatal Care Leave and Pay Act has received royal assent, which means that it is now firmly established as a piece of legislation, and regulations now must follow to implement it. Now, this next piece of legislation, as you'll see, is still referred to as a bill, the Worker Protection Amendment of Equality Act 2010, Bill of 2022 to 2023. This piece of legislation has seen a bit of an up and down route through the House of Commons and the House of Lords, because it has to go through various readings before it gets approval. This piece of legislation has now had, just last week, on Friday of last week, it's had its final reading in the House of Commons and has now been approved. It hasn't received royal assent yet, but that should be a formality. So, cut to the chase, Matthew. What on earth is this legislation doing? Well, it's going to introduce a proactive duty on employers to take reasonable steps to eliminate sexual harassment from their businesses. So you might say, well, surely we do that anyway already, don't we? Well, as far as the law is concerned, do employers actually have to do anything to stop harassment in the workplace? And quite frankly, although this seems like a stupid question, there's nothing at all that employers are required to do in law. Nothing. That's not to say that there aren't consequences for employers if they don't try to stop harassment. Workers and employees can, of course, bring claims of harassment under Section 26 of the Equality Act. But the bringing of the claim in itself doesn't necessarily mean that an employer has to do anything to stop harassment. After all, they can settle claims and just carry on as before, as perhaps is evidenced by a number of the high-profile cases that came out of the Me Too movement. So this called into question whether the current legislation actually works. Well, so what progress have we made since the Me Too movement? Well, arguably, it's very limited. We've seen a report, and I'm sure you probably read about it in the press. We saw a report recently that nearly 2/3 of female surgeons said that they'd been the target of sexual harassment. And a third had reported that they had actually been sexually assaulted by colleagues in the past 5 years. And these are truly horrendous statistics. And so it now appears that we're going to have legislative change in order to require employers to take preventative action. And that's what this bill does. As I said, it appeared to have stalled in the legislative process, but that's because the House of Lords in particular were objecting to a significant part of the legislation, which set out a reintroduction of third-party harassment. Now, I'm not intending to get into third-party harassment now. Essentially, the House of Lords objected to that, so that's been removed from this legislation. But however, as I said, the legislation has now passed its final reading. So what does the legislation say? So let's have a look at what it says. So it's going to introduce a legal duty on employers to take all reasonable steps to prevent sexual harassment. And sorry, I'm just going to correct myself there, because I've just said all reasonable steps, and that's incorrect. It will introduce a legal duty on employers to take reasonable steps to prevent sexual harassment. The reason I just said all reasonable steps is because the House of Lords did water down what employers need to do. the legislation originally required employers to take all reasonable steps to prevent sexual harassment, and that's been watered down slightly to requiring employers to take reasonable steps. So not all reasonable steps, just reasonable steps. So what do we mean by reasonable steps? That is a bit of a question which I'm going to turn to on the next slide. But before I do so, one of the interesting things of this, of course, one of the additional interesting things of that is that this legal duty will not apply to the other forms of protected characteristics in the Equality Act. This is focusing solely on sexual harassment. Although, of course, I would have thought that many employers, under their obligation to address sexual harassment, take a proactive step to eliminate sexual harassment from the workforce, will also do take similar action in relation to the other protected characteristics, but there isn't actually a legal requirement to do so. So what are these reasonable steps? What do we have to do? Well, it's always interesting for us as advisors and also employers to get some guidance from the tribunal about the use of reasonable steps. So essentially what we've got at the moment, so reasonable steps already exists. So currently under section 109 of the Equality Act, essentially it states as follows, that in proceedings against an employer in respect of anything that's alleged to have been done by the employer in the course of that person's employment, it is a defence for the employer to show that it took all reasonable steps to prevent the harasser from doing the thing that they did. What this means is that as an employer, if an employee of yours acts in a discriminatory way towards another employee, then you can avoid liability for that if you've taken all reasonable steps to prevent them from acting in that discriminatory way. So in order to be able to run this reasonable steps defence, all reasonable steps defence, it is commonly regarded that the minimum that an employer must do as an absolute minimum is have an equal opportunities policy or an anti-harassment policy, that the policy has been clearly and effectively communicated to everyone, that training has been undertaken in relation to dignity at work, equal opportunities, harassment, and that action is taken when complaints are raised within the business. So I'm sure an awful lot of that is rather familiar to you. Many of you will have these policies in place. Many of you will be ensuring that those policies are communicated. Many of you will have undertaken training in relation to dignity at work or harassment or equal opportunities, albeit that I must admit that I do find that the consistency of that training, the quality of that training, the regularity of that training can be problematic in some employers. And so what do we mean as reasonable steps? So what do the tribunals think of reasonable steps? So what I thought it would be quite helpful to do is just to highlight some recent cases that have set out what they think about whether an employer has taken reasonable steps. Because of course, this is going to form the basis of this proactive duty that employers are going to have. So in this case, the Leader and Hossack case, which actually, as you can see, involves Leeds City Council, but because Leeds City Council successfully ran the all reasonable steps defence, they were therefore removed from the proceedings, the later proceedings that continue, which is why they're not named in the case. But Leeds City Council was successful in demonstrating that they had taken all reasonable steps and showing that they had a clear dignity at work policy, they trained all staff, and they had a culture of allowing employees to raise concerns. So that all seems quite straightforward, doesn't it? So in many instances, an employer is then going to feel, or you might read that and feel quite confident in where you are as a business. But then we've got this quite recent case of Fisher and London United Busways Limited. Quite an interesting case. I'd encourage you to go and have a read of it because it's one of those cases where the tribunal clearly identified quite early on that harassment had not taken place. But notwithstanding that, they took the opportunity to really delve into a couple of issues and give their views about things. And one of them that they took a view on was the reasonable steps defence that was run by London United Busways. Now, London United Busways is quite a large employer. It provides bus transport services in London. And they ran the reasonable steps defence in this case. And in this case, they had all of the following. So they had an equal opportunities and harassment policy from 2007. The policy emphasised that it had a zero tolerance approach to the enforcement of the policies. The policies were not only given to all employees, but it was also provided to all the agencies that provided workers to the business. The policies were part of the employer's induction process. Everyone was encouraged to report concerns, and there was evidence that complaints were investigated and addressed. So again, you might have a look at this and think, well, how is that different to the leader case that we just looked at? Surely that is going to be sufficient for a reasonable steps defence. Well, you can clearly see where I'm going with this, because it wasn't. So what the tribunal said was that they should have more up-to-date policies. So their policies hadn't been updated since 2007, and they said that that wasn't sufficient. The policies had to be clearer. They had to be clearer about what sort of behaviours were unacceptable. They had to be clearer about who they apply to. They had to ensure that the approach of the business isn't just about equality, but it's also about inclusion. So this is where the fact that the policy dated back to 2007, this is where the tribunal was saying you haven't kept up to date. It's not just about equality anymore. It's about diversity. It's about inclusion. It's about the inclusion of minority groups at work. But although the policies had been sent to all agencies and that they were part of the induction process, that the communication of the policies should have been improved. Notice boards weren't sufficient. That the training that they had should be regularly refreshed and more detailed, that also address the meaning of terms, for example. So the use of language, what sort of language should we be using, and what sort of language should we not be using? That an organisation of the size of this employer should also have had employee representative groups. So, for example, the minority group, so the LGBTQ plus representative group, or a minority ethnic representative group, and that support from an employer in the formation and operation of such groups can allow ideas for improvement to come from diverse groups and enrich and improve the business's approach to issues affecting those groups. Effectively finding a way to communicate directly with all of the different groups within your business so that you know how to properly include those minority groups within your business. And so that's what the tribunal said should have happened. And so, as you can see, that really is quite a comprehensive list of things that an employer should be doing. And it really does set the bar quite high. Now, as I've already said at the beginning of this, is that what the legislation is doing, though, is it's not necessarily setting the bar as high as this, because the legislation that is going to require employers to take proactive steps to eliminate harassment, sexual harassment in the workplace, is reasonable steps and not all reasonable steps. So we are going to need to have some guidance on what this actually means. And we've been promised that the Equality and Human Rights Commission is going to publish some guidance around this. And also to let you know about where we are in terms of the enforcement of this, is that the enforcement of this is going to be done by the Equality and Human Rights Commission. So what this effectively means is that there's the possibility of you know, in a case where, say, for example, you haven't taken these proactive steps, or arguably you haven't taken these proactive steps to eliminate sexual harassment from your workforce, then when you receive a complaint of sexual harassment, then that individual may threaten or actually do so in making a complaint to the Equality and Human Rights Commission. So effectively reporting the business to the Equality and Human Rights Commission and asking them to investigate. Perhaps in the same way that where an individual alleges that we breached data protection, that they will do so, make those complaints to the Information Commissioner. The Equality and Human Rights Commission can then investigate, and they will have the power to intervene and to fine businesses. Although it's not quite clear at this point in time what we are looking at in terms of levels of fines. More practically, what can also happen is that there is likely to be a provision within the legislation that is then going to allow the increase in compensation at tribunals. So in the same way at the moment that if you don't follow the code of practice for disciplinary and grievance processes, you then lose a case in tribunal in relation to, you know, say an unfair dismissal claim, then the tribunal can uplift the compensation as a penalty by up to 25% for your failure to follow that code of practice. And this will happen with sexual harassment cases as well, where the compensation can then be increased. So there is obviously there is, of course, employers should be taking steps to eliminate sexual harassment from their workplace in any event. I think we would all agree on that, and that's a given. But the bottom line of this is that if you don't, it's going to cost you money. So we can provide you with a template sexual harassment policy. Now, I'm sure you all have anti-harassment policies, but those anti-harassment policies tend to be quite broad and generic, certainly from my experience of the ones that I have seen. And in order to ensure that you are actually taking proactive steps to eliminate sexual harassment specifically, then I would strongly encourage you to get a sexual harassment policy in place. One of the other things that tends to come out of all of these cases is in relation to training. And as I said, that's probably the one area where employers are most inconsistent. So you need to have a look at your training. Now, of course, we can help you with that training. I say we can help you with that training. Yes, we can help you with that training. We can deliver that training for you, whether that be diversity and inclusion awareness training more broadly, either for all employees or more specifically for team leaders, supervisors, managers, about how to address complaints, how to be on the lookout for complaints. Because obviously the responsibilities for team leaders and supervisors and managers is different to employees. So you need a different training session for those individuals. And then more specifically, obviously, in relation to sexual harassment, so sexual harassment awareness training for all employees, and also then specific training in relation to managers regarding what they should be looking out for and how they should be dealing with and addressing complaints. We've got e-learning packages which you can use. We can also come into your business directly and conduct investigations into sexual harassment. We can conduct grievance and disciplinary hearings into sexual harassment as well. Or, of course, we can provide some training in relation to your own employees in order to enable them to feel comfortable and secure about what they should be doing and how to approach complaints about sexual harassment. Because complaints of harassment, and I'm hesitant to say particularly complaints of sexual harassment, but I've got to say that certainly the complaints where I have got really very close and first-hand experience of from an advisor's point of view, and from conducting meetings, is that sexual harassment is probably one of the most upsetting areas. That's not to say that the other areas of protected characteristics, whether it be racial harassment or the other areas, are not upsetting. I'm not saying that whatsoever. But often sexual harassment can be a very difficult one for employers to deal with, and for managers to question employees about, and therefore investigate these issues. So if you want some help with that, then obviously please do get in touch with us. Now, that is not the end of the legislation that's coming through. We've still got more. So we've got the Employment Relations Flexible Working Act of 2023. So what does this act do? Well, you've probably read about this act quite a bit already. And the changes that it are making are, to be honest with you, quite straightforward. This isn't a fundamental change of regime, unlike the, say, for example, the introduction of proactive duty to eliminate sexual harassment from your workplace. This is about making tweaks and changes to current flexible working regulations. So these are procedural changes. So employees are no longer going to have to explain what effect their application has on the business, or how that effect may be dealt with. They're going to increase the number of applications that can be made. At the moment, it's only, I say only, it's one application in any 12-month period. That's going to be changed to 2 in any 12-month period. Employers will not be able to refuse a request unless the employee has been consulted, but the reasons by which you must, the 9 reasons by which you must use to reject the request remain the same. Employers will have to make a decision within 2 months. That's been reduced from 3 months. And there's also an expectation, although it's not actually interesting, it's not written into the legislation itself, which, seeing as it seems to be the big headline that's been reported in all of the HR press, there's an expectation that this is going to now be a day one right. But it's actually not in the legislation at the moment. Again, there's regulations to follow, so therefore we expect the day one right to be put in those regulations, and we are expecting new ACAS guidance to follow shortly as well. The ACAS are currently consulting on that guidance at the moment. And still we go on. Protection from Redundancy, Pregnancy and Family Leave Act of 2023. So this is the legislation that I mentioned I would talk about a little bit earlier when we were talking about the neonatal care leave, and whether there was going to be any protection from redundancy within that. Now, at the moment, currently, if a woman is on maternity leave and she's at risk of being made redundant, she must be offered any suitable alternative role that exists over and above any employee. Now, we are anticipating, well, I say we're anticipating, we know that from this legislation that the government is proposing to extend this period of protection. So at the moment, the protection ends at the end of the period of maternity leave. So as soon as the woman returns from maternity leave and comes back to work, she no longer has the right to be offered any suitable alternative vacancy over and above any other employee. So perhaps what we have been seeing with the more unscrupulous employers is that they've been simply waiting for the woman to return from maternity leave and then undertaking the redundancy process in order that this protection is not triggered. So what the government is proposing to do is extend that period of protection for a period of time after the woman returns to work from maternity leave. It's anticipated, and again, it's going to be confirmed in the regulations, but it's anticipated that that's going to be for a further additional period of 6 months. We're nearly there in terms of the legislation, I promise you. But like I said, there is just an awful lot that the government has been publishing recently. I think it's been playing a bit of catch up from where we were previously. So the next one, the Workers' Predictable Terms and Conditions Act of 2023. Sort of does what it says. So what it's essentially, so over the past 10 years or so, we've seen significant increases in the use of zero-hour contracts and, you know, the growth of the gig economy. And this has been criticised in many quarters as some employers have been exploiting workers and given no security of work at all. And sometimes, previously anyway, even preventing them from working elsewhere as well. Now, at the end of 2022, we saw the banning of exclusivity clauses in 0 hours contracts initially, and then also that being extended to low income workers, those being the workers that earn less than the lower earnings limit of £123 per week. So now, September 2023, we've seen the Workers' Predictable Terms and Conditions Bill receive royal assent, which then becomes the Act. Now, essentially what this is going to do is it's going to, in circumstances where there is a lack of predictability in the work pattern that an individual worker or employee has, they are going to have the right to request a more predictable pattern. 2 applications can be made in any 12-month period, and statutory grounds can be used to reject that request. And those statutory grounds, very similar to the statutory grounds that are set out in the flexible working regulation. So it's the burden of additional costs, detrimental effect on ability to meet customer demand, detrimental impact on the recruitment of staff, detrimental impact on other aspects of the employer's business, insufficiency of work during the periods the worker proposes to work. Oh, excuse me, sorry. Oh dear, my apologies, excuse me. So claims will be possible based upon procedural failings of the employer and unlawful detriment and automatic unfair dismissal. And even where the individual is an agency worker, they may also make an application for predictable working hours to their temporary work agency with whom they have a contract to perform that work. And they can also make an application to the end user. So you can potentially see applications coming from agency workers. We're expecting this to come into force in around October 2024. ACAS are going to produce a code of practice and provide more guidance on the handling of requests and, of course, the making of requests. And we're expecting the draft consultation of that to be coming out any moment soon. Possible legislation on the way. Now, so this isn't, so everything that I've talked about so far is legislation that has passed and received royal assent, with the exception of the proactive duty to eliminate sexual harassment, which is just in the last stage. So we're expecting that to receive royal assent very soon. That should be just a procedural process. Now, this next bit hasn't got this far, so this is less certain, but it is still a very strong possibility. So essentially, it's the possible restriction on restrictive covenants. So the government has been consulting on restrictive covenants and their use. And what they have said is that they want to introduce a 3-month limit on the duration of non-competes. So essentially, what we've got is the government wants to remove a degree of uncertainty and restriction that exists around non-compete clauses. Because at the moment, quite commonly we will see in employment contracts sort of template post-termination restrictions. They're usually for 6 months. And employees are either scared to or nervous to breach them, and so don't do so, which then restricts their ability to move about in the labour market. And of course, the government, I say of course, the government's approach to this is that they want to make the labour market more flexible, and that they think and believe that non-compete non-compete clauses, not non-compete clauses, non-compete clauses are restricting the ability of employees moving from one employer to another. And so they've looked at ways in which they can better manage this. One of the things that they were looking at were to make employers pay. Say for example, you must pay 3 months' pay in addition in order to get 3 months protection, something like that. But they've decided not to do that. They've decided that as part of their response to this consultation that they're going to limit it to 3 months. Now, as I said, this is just proposed, so we're waiting to see if this legislation will actually come through. We would expect it to be honest, but obviously there's going to be government is going to be somewhat busy. I would have thought over the coming months, as everyone is going to be preparing. We expect for a general election at some point in the first half of next year. So whether this gets through in time, we'll have to wait and see. But I just thought I would put it on your radar so that you know that there is a possibility that you're going to have to review these clauses and amend these clauses in due course. So that is enough legislation for now. And this is one of the reasons why I put this in for an 1.5 hour session rather than a 1 hour session, because as you can see, we're 55 minutes in and we've only just got through the legislation. Now, the next part of this is much more straightforward. Is quite helpful because, of course, guidance is helpful. We all love a bit of guidance. So what have we got? We've got ACAS publishing some new guidance on mental health. So we have got within this document, for the first time from ACAS, because they haven't published a document in quite as much detail as this before in relation to mental health. And of course, the management of mental health in the workplace has become something that certainly I, as an advisor, have seen growing and growing and growing with each passing year, and particularly since the pandemic. So what this guidance does is it provides useful help for employers to manage employees who experience difficulty with their mental health, how to reflect the support that you want to provide in relation to mental health in all your company policies. Now, of course, we know that there is a duty to make reasonable adjustments under the Equality Act. But of course, the requirement to make reasonable adjustments is only triggered when a mental health condition falls within that definition of Section 6 of the Equality Act. What this guidance is doing is it's encouraging employers to take a more proactive approach to the making of such adjustments to help employees stay at work, whether they're disabled or not. And so one of the parts of this that I must admit that as an advisor, I think is particularly helpful, and it's why I'm providing this slide as it's set out here, because this is essentially a copy and paste of one of the parts of the guidance, is that what the guidance is doing is it's publishing a number of case studies about how some organizations have implemented reasonable adjustments. And they're also providing short fact sheets for employees and employers and template letters and case studies. And so it's a much more practical piece of guidance that we've seen before. But of course, what it's also doing, as you can see from this example, is that this is suggesting the things that employers should be doing. And so by suggesting the things that employers should be doing, then of course, any employee claimant who is then challenging you in an employment tribunal as to the level of support that you've provided, that if you're then not having provided the support that's set out in the ACAS guidance, then we're going to have reason as to why. And you can see from these bullet points that are provided here that this is perhaps raising the bar somewhat in terms of where many employers are at the moment. So I'd encourage you to go and have a look at the document, not just a look at the document, read the document, download the document, share it with your HR colleagues and senior management, and have a think about what support you want to provide your employees in relation to mental health. And of course, this should then be reflected in the training that you provide to your managers and your supervisors. So again, it's about making sure that you communicate this throughout the business, because one of the problems that we frequently find is that the business may decide that it's going to take a particular approach in relation to mental health, but if it's or in fact any other initiative, but if it doesn't effectively communicate and train the managers to be able to deliver that on the front line, then often it gets missed and it doesn't happen. And this is the issue of having policies and having initiatives, but not actually having strong implementation plans that sit around that. Some more guidance from ACAS. Guidance on suspension. So this is reflecting recent case law that we've seen in relation to suspension. Essentially, cutting to the chase, it shouldn't be a knee-jerk reaction to suspend somebody. What we should be doing is suspending people where we need to suspend somebody. And so what this guidance is also doing for the first time is actually providing clear alternatives as to what employers can do instead of suspension. So can you change shifts? Can you get that person to work from home, or change the site that they work from? Can you get them to work with different customers or away from customers, or work with different systems? So lots of alternatives. So simply because, say for example, simply because the individual is accused of an act of gross misconduct, it doesn't automatically follow, or it shouldn't automatically follow, that that person is then suspended as a result of that. Now, often they will be, and often that will be justified, but sometimes it can be challenged. Because of course, if we, for example, if we go back to an allegation of harassment, for example, where there may be one word against another, it might be strongly disputed. But if we are then automatically suspending the accused, and that the accused might, for example, be someone who is relatively high profile in the business, and others see that person being suspended or know that that person is suspended, then that can undermine their position at work and can actually lead to a fundamental breach of contract. That's very much in the exception, but we've got to be alert to it. So we've got to ensure that when we are suspending somebody, that we should be taking into account this guidance that's been published by ACAS. So again, as I said at the beginning of this session, I will be providing all the links to all of these pieces of guidance when you get the packs. Sent to you, which won't be later on today, but it will be tomorrow that I get the packs out to you, if that's okay. So another piece of guidance. So guidance from the CIPD, Chartered Institute of Personnel and Development, obviously. This is guidance in relation to the inclusion of transgender and non-binary workers and employees at work and in the workplace. Now, obviously, this is has become quite a contentious issue within society. But then that's why this guidance is really important. So employers and advisors and tribunals alike have been grappling with the current social discourse that there has been regarding transgender and gender fluidity and non-binary employees and workers. We've seen an increasing number of high-profile cases in the employment tribunals. We've seen the gender-critical cases of, and again, these links will be in the pack when you get them, of Maya Forstater, Alison Bailey, David Macareth, Higgs and Farmer School. All of 4 of these cases have shown how the law protects those who are critical of gender assignment, who are critical of gender identity and transgender issues, albeit that these cases are emphasizing that that protection is limited to circumstances where those critical beliefs are manifested in a reasonable and appropriate manner. But we've also seen important cases where transgender employees have successfully brought claims as well for discrimination and harassment. And that's not at all surprising, given that recent research has shown that more than 40% of LGBTQ plus and 55% of trans workers have experienced discrimination, physical or sexual assault in the workplace in the last 12 months. And 25% of LGBTQ plus young adults went back into the closet when they started work. And this is research that was also conducted by CIPD. The most notable of these cases, and one with a very well-written judgment, which I would encourage you to go and read, is the Taylor and Jaguar Land Rover case. I'm not going to go into that case in detail here, or those other 4 gender critical cases that I mentioned, but I will provide the links to you in the slides. But with all of these cases in mind, this guidance from the CIPD is incredibly welcome. So what does the guidance say? Well, as you can see from those bullet points, which no doubt you've been having a read of whilst I've just been talking about the generality of the issue of transgender and gender identity in the workplace. So they're providing guidance on maintaining dignity and respect, as you would expect, providing day-to-day support for transgender and non-binary workers, how to effectively draft a diversity, equality and inclusion policy and how best to deliver that training, an explanation of specific challenges of transgender and non-binary experiences from recruitment onwards, and suggestions on how to attract transgender and non-binary candidates, and guidance on how to support the transitioning work and how to deal with transgender and non-binary workplace conflict. And there's also some guidance in there about using inclusive language and transitioning at work plan prompts. So there's an awful lot of really very useful information within this guidance. So again, I would encourage you to have a read of it. Must admit, I can't recall whether it's limited to CIPD members or not. I will provide the link, and apologies in advance if it is behind the membership paywall. But it is a very useful, like I said, a very useful piece of guidance for us all. Also, if you are wanting to implement a policy in relation to transgender and non-binary issues at work, we do also have a template policy in relation to that. So, Information Commissioner's Office, they published some guidance on lawfully monitoring workers. Now, with the advent of a returning new season of Big Brother, I thought the image was appropriate, and also the launch of this guidance is therefore also very timely. So what's this guidance saying? So this guidance follows some research that was conducted by the ICO, which revealed that almost 1 in 5 people surveyed believe that they've been monitored by their employer, and over 2/3 would find monitoring in the workplace intrusive. And that 1 in 5, fewer than 1 in 5, sorry, would feel comfortable taking a new job if they knew that their employer would be monitoring them. And it's also quite clear that since the COVID pandemic and the significant increase in working from home, alongside lots of developments in relation to technology, that employers are seeking to carry out checks and monitor workers on a far more frequent and continuing basis than had previously been the case. So what this guidance is doing, or is intending to do, is help employers comply with their obligations under the Data Protection Act of 2010. And so again, just some bullet points there of what steps you should be taking to ensure that when you are monitoring workers, that you are doing it lawfully. So making them aware of the extent and reasons for the monitoring, having a purpose for the monitoring, having the least intrusive way possible of achieving it, obviously having a lawful basis for processing that workers' data, which is one of the basic principles of the GDPR. Telling workers, informing workers about the basis of which you're monitoring in an understandable way, only keeping information that is relevant to that purpose, and if needed, then carrying out a data protection impact assessment. Okay, so all relatively obvious stuff. So next, well, we've been seeing lots of useful guidance in relation to the menopause coming out over the last few months. And so I'm just going to run through some of those pieces of guidance that have been coming out. First of all, we have got a survey of workplace adjustments. So this is this isn't from a document such, this isn't ACAS guidance or anything quite as significant as that in the tribunals. But this survey sets out what adjustments women find most helpful for managing issues connected to the menopause at work. And there is nothing that's particularly unsurprising there. And in fact, I'm sure that a lot of employees would be asking for those sorts of things for a working environment that reflects that anyway. But it's obviously particularly important for women who are experiencing the menopause. What else have we got? Right. Well, we've also got a government action plan. Now, we have seen that, as I said, that there's been lots of momentum around the issue of menopause in the workplace. And we're seeing a lot of guidance being published about how employers should take a non-discriminatory approach at the very least, and a positive attitude to the menopause, and encouraging a genuinely positive and inquisitive attitude that we're seeing from a large number of employers that are approaching this issue with an open mind and wanting to help. And it appears that both the Conservative Party and also the Labour Party appear to be ensuring that they're not going to be left behind on this important social development. So with this in mind, just a couple of weeks after the Labour Party announced at its conference that it was committed to publishing menopause guidance for small business, the government has itself published a policy paper now providing a summary of the work that its menopause employment champion, a lady called Helen Tomlinson, has undertaken to date. Now, this has resulted in a 4-point plan, which will initially focus on the hospitality, retail, care, and manufacturing and professional and technical sectors. And what this 4-point plan is focusing on is providing a portal for employers within a sector to share best practice, a sector-based allyship program for women, for there to be a menopause-friendly employers to act as advocates within the sector, and a sector-based communication plan. Now, actually, and although I should have put this as an additional bullet point on the slide, but I'm sorry for not doing so, one of the key parts of this plan is that they're going to be providing a one-stop shop for menopause resources and guidance for employers and employees. It's the help to grow campaign.gov.uk. Again, don't worry, the link will be in the pack when I send it out to you. But that provides a central resource for you to be finding additional guidance and help. So that's going to be hopefully very useful, because like I said, there's quite a bit being published at the moment, both by the government, both by the Labour Party. We're seeing quite a lot being published by other groups. So, for example, the Fawcett Society. And again, so we've had a look at whether we need an additional policy for sexual harassment in the workplace, whether we need an additional policy in relation to transgender and non-binary issues. Also, I would encourage you to be looking at a policy in relation to menopause at work as well. Now, the issue of menopause takes us seamlessly into some case law. So for the last 20 minutes of the session, I'm going to be addressing some of the recent cases. As you can probably tell from the way that I've split the session up, but actually this session was very much heavily focused on the legislation that's coming into place, but there are some useful cases that have been published as well. So the reason that this is a seamless move, unlike that my verbal introduction into it, a seamless move into case law is because the first case is about menopause and reasonable adjustments. So this is the case of Lynskey and Direct Line Services. So Mrs. Lynskey was a telesales consultant. She resigned from her employment with Direct Line after 6 years service in May 2022. She brought claims of constructive unfair dismissal, sex discrimination, and age discrimination. All of these claims failed, but she did also bring a claim for disability discrimination based upon the failure of Direct Line to make reasonable adjustments under Section 20 of the Equality Act, and that she'd also been complaining that she had been discriminated against because of something arising from her disability under Section 15 of the Equality Act. Now, Mrs. Lynskey had performed well in her role from 2016. She then began to experience symptoms of the menopause in 2019. These included low mood, anxiety, mood swings, poor self-esteem, effects on memory, and poor concentration. And around this time, she also then started to struggle to meet the standards required of her in her role because of those menopause symptoms. So Direct Line then proceeded to manage her underperformance. This included moving her to a different team, giving her a rating in her annual performance appraisal, which meant she didn't get a pay rise, all of which resulted in financial losses of around £3,500 a year to Mrs. Lynskey. Formal performance management proceedings were then also commenced, and they also concluded that it would not continue to pay her sick pay because of a level of absence was unsustainable, despite the fact that she appears to have only used half of her sick pay entitlement at the point that that decision was made. So, what adjustments should have been made? Well, as you can probably gather, her claims in relation to disability discrimination were successful. And they said that the adjustments that Direct Line should have made were that her targets should have been reduced, was that consideration should have been given to her being able to undertake a non-telephony role. So essentially, she was on the telephone talking to customers, often difficult customers, and that then resulted in increased level of anxiety. And given the level of anxiety that she was already experiencing as a result of the menopause, that was then affecting her performance. And therefore, in order to adjust that the role to a non-telephony role, given that a mailbox team existed, which would then avoid her having to talk to those challenging customers and therefore provide her with a greater opportunity to meet her targets. A disciplinary process should have been abandoned. The mitigation that was provided by Mrs. Lynskey should have been accepted. So this case really does highlight that consideration must be given by employers for women who are experiencing the symptoms of the menopause. Now, whilst the law might not be entirely satisfactory, in that it does remain a requirement for women to show that the menopause is a disability in their specific case, which personally I think is entirely unsatisfactory. After all, a pregnant woman doesn't have to show that she is experiencing a disability as a result of being pregnant, but that's an argument for another day. But it would still be prudent for employers and good practice and sensible to always consider reasonable adjustments when one of your employees is experiencing the symptoms of the menopause. So this goes back also to the guidance that ACAS have published in relation to mental health. So the underlying theme of the guidance that ACAS have published in relation to mental health and making reasonable adjustments in relation to mental health is don't wait for the person to be disabled. Whilst the legal duty is only triggered when somebody is disabled, it can be very unsatisfactory for an employer to wait until that time. And of course, there's often a level of uncertainty about whether somebody is disabled or not. Now, as I said, Mrs. Lynskey won her claim. She was awarded £30,000 for her lost earnings, both past and future. She was also awarded £23,000 for injury to her feelings. and a further £2,500 for aggravated damages. And this was as a result of the way that Direct Line conducted their defence of the case, and specifically the fact that they would not concede that she was had a disability under Section 6 of the Equality Act until very late in the litigation process. So again, they were having an argument which they really needn't have had around disability. So go out there and proactively identify the adjustments, make the adjustments. Don't hold everything on whether somebody is disabled in the eyes of the law. So more on reasonable adjustments. Yes, so recruitment and reasonable adjustments. So this case, the AECOM and Mallon case, this was a case which essentially what this comes down to is that the employer had an online recruitment system which required all applicants to fill in an online profile and complete an online application form. The applicant in this case had dyspraxia and asked in an email correspondence with the HR department in bold capitals that he be permitted to make an oral application because of his disability. The employer made some inquiries with Mr. Mallon as to why he needed to do that and to explain his difficulties by email, but he failed to do so. Now, either Mr. Mallon was being deliberately obstructive in order to engineer a disability discrimination claim because he was not a genuine applicant, or he was having genuine difficulty with written communication. And essentially, the reasonable adjustment in this case was that the employer should have telephoned him, and it shouldn't have continued the online correspondence with him. So this is where you might think that you're making the appropriate adjustment, but if you are not making exactly the adjustment that is required to alleviate the disadvantages in the eyes of the tribunal, then we're going to catch a cold. So this illustrates the importance of having robust internal procedures for dealing with issues that might arise during recruitment exercise. Because of course, recruitment exercises are still entirely relevant in relation to the making of reasonable adjustments in the same way as is the case when somebody is actually an employee. The impact of childcare on the hours that women can work. So this is Section 19 of the Equality Act. And what Section 19 of the Equality Act sets out is indirect sex discrimination. Now, of course, flexible working is in the news at the moment. We're all awaiting the implementation of the changes to flexible working through the Employment Relations Flexible Working Act 2023, which I've already spoken about a little bit earlier. And that legislation will mean that an employee will no longer have to explain what effect, if any, they think their request for change would have on the employer or how that should be dealt with. But I'm not going to go and repeat that necessarily. Now, but being brutally honest, it really isn't very difficult for an employer to comply with the flexible working regulations, and in many instances simply refuse requests. The only real consideration that employers often have when assessing applications for part-time work is the risk of indirect sex discrimination claims under Section 19 of the Equality Act. And what Section 19 of the Equality Act says is, do women experience group disadvantage? And I'm saying women in this instance because I'm looking at indirect sex discrimination, and in particular the requirements to perhaps work full-time instead of working part-time, or to work a particular pattern of hours which women are less able to comply with. So the question that Section 19 asks of any employer is, do women experience group disadvantage because of childcare responsibilities? And if so, whether the refusal of a request was a proportionate means of achieving a legitimate aim. So, turning to the facts of this case. So, Mrs. Dobson had a long-standing arrangement to work 2 fixed days a week. The NHS Trust that she worked for wanted to change this arrangement as it needed her and others undertaking her role to work occasional weekends. It gave notice to everyone of this change, and the reason for this change was that the provision of community nursing was expanding into more of a 24/7 service and treating patients at home with more complex needs. So the nature of work was changing. Now, Mrs. Dobson said that she was unable to change her fixed days or work the occasional weekends because she had 3 children, 2 of which were disabled, and she had nobody else that could assist her with childcare beyond what they were already doing. Her mother-in-law provided the childcare on the Wednesdays and Thursdays for the days that she did work. Because Mrs. Dobson was not able to comply with the changes, the trust offered her a new contract with the new hours and warned her that if she declined the new terms, her employment would be terminated. And Miss Dobson was subsequently dismissed under those terms. Now, so this case then it goes to the Employment Tribunal, it then goes to the Employment Appeal Tribunal, and then it comes back to the Employment Tribunal. And the NHS Trust succeeded with their defence of the case. And they succeeded on the basis of the proportionate means of achieving a legitimate aim. And as you can see here, the tribunal has commented that the organisation's needs as a whole, especially for an NHS Trust, must sometimes prevail. A rigid application of the principle that a woman with childcare responsibilities may choose a fixed working pattern is liable to lead to problems with the delivery of service to patients and in the relationships between colleagues. As happened in this case, where small teams of nurses are sharing the responsibility for covering a flexible rota, including some weekend working, justice and resentment can arise where a few individuals are carrying the lion's share of unsocial hours working. Word of caution, though. This does not give employers carte blanche to succeed with a proportionate means of achieving a legitimate aim defence. What is particularly important in this case is the facts of the case, the facts that the nature of the service was changing, the fact that it was providing health services to the public, a very important service. The knock-on effect of not being able to deliver that would be very significant indeed. As a general rule, you have to go some in front of an employment tribunal to show that you cannot accommodate the working pattern of the individual. At the very least, one of the things that we should always be looking at is the option of job sharing. Obviously, that wasn't a possibility in this instance for obvious reasons. Now, what I would do is that there are various cases, various interesting cases in relation to childcare disparity and indirect sex discrimination. Again, I'll pop the links in the pack when they come out to you. London Underground versus Edwards, ESOC versus Home Office, Chief Constable of West Midlands Police versus Blackburn, and a few others as well. I will get those out to you in the pack. And then don't worry, final case for us. A little left field, a case about restrictive covenants and stopping unfair competition. Now, we spoke about this a little bit earlier on in terms of the potential legislative change that might be happening in this area. Work effectively, all this case says is if you are intending to try to enforce any restrictive covenants, do not delay. In this case, the company delayed. It made minor attempts to try to sort this out in the first instance, but it left it too late. And essentially the court said, it can't have been that important to you if you delayed. And as you can see here, the company knew about the misuse of their information in July 21, but didn't take any steps to prevent the use of that information until December 2021. And so on that basis, it can't have been that important. And that concludes our session. Thank you so much for attending. Thank you so much for seeing it through to the end. Please do keep an eye out for future events. Please do subscribe to our mailing list. I will, like I said, I'll put all the detail out to you in the packs that you receive it. So you can subscribe to our email updates, have a look at our website for email updates as well. We run regular events such as this. We're going to be re-establishing our podcasts as well. So we do have a regular podcast, albeit that I haven't done one in a little while, but we'll be doing those regular podcasts to keep you up to date. There are obviously lots of services that we can provide, both in terms of those template policies that I've talked about, and also, of course, legal advice and any assistance that you might need in resolving disputes. We do so on a retainer basis to make it cost effective for you, spreading the cost out over the course of the year. Like I said, I'll put the detail in the pack. I won't bore you with all of that now. But yes, I hope that you have found this useful. Have a really good rest of the day. So please do enjoy the rest of your day, enjoy the rest of the week. We're halfway through now, and I'm relieved that I've timed that so that it's pretty much on the dot of 2 o'clock. So thank you very much. I'll be in contact via email very shortly with all the information. Thanks very much. Bye, everyone.